Please be seated. Thank you, Ms. Waldron. Just before we start the program today, assuming that we are still sitting at 11, I'll invite you to join the commissioners in the customary remembrance, and then that might be an appropriate time to take the morning tea break. So that would be 11 a.m. Mr. Futrell will.
I'm rising. I don't wish to interrupt you, Mr. Commissioner. If you finished, there's a couple of matters of housekeeping nature I would like to deal with before we start.
Please.
First is, given obviously the next witness is Ms. Waldron, as you know. Given the topic and subject matter of her evidence, it would probably be best to make an assumption that all documents that are going to be viewed during the course of her evidence will be the subject of an NPO. So they'll be confined to the Commissioner's screens and to the interested parties' screens. And the second is, I want to clarify before any of the interested parties examine Ms. Waldron the nature of, the scope of her instructions and the nature of reliance that may be placed on the opinions that are expressed in her report. And it's probably easiest if I do this by reference to the report itself, because it would be necessary to take the Commission and the parties through the parts of the report that are affected by what I'm about to say. So if we could call up PCRC .0021, .0001, .0121, and scroll, if we could, to 0164, which sets out landscape versus scope for Ms. Waldron's part of the report. I want to draw everyone's attention to the topic, theme 1, and preface what I'm about to say by indicating that in the context of compliance reviews or assessments of experts in this field, they are or may be called upon to express a view about whether or not AML CTF programs are compliant with the AML CTF Act and rules. The view expressed in doing so, of course, does not mean that there is in fact, as a matter of law and fact, non-compliance with the AML CTF Act and rules. It's the view expressed by the expert as to essentially their understanding of the rules, the Act and rules, and whether or not the program is compliant. So the question that is dealt with in theme 1, and the focus here is on Crown satisfies its obligations under the AML/CTF Act, is of course calling for the expression of an opinion based on the author's understanding of what those obligations are, not calling for an expression of opinion as to the legal effect of the AML and CTF Act. Likewise, if you see the way in which the scope is broken up, it starts with the theme, and then there's tasks in the column on the left-hand side. The first task indicates whether there should be an assessment as to whether there's a compliant AML CTF program. Again, that is calling for the expression of an opinion based on an understanding of the what compliance is required. It's not requesting a legal opinion on the meaning of the Act and rules. So if I could just also draw attention to one other aspect under the theme, which is the focus really of the question. You'll see there's an asterisk after material deficiency, and then it's described as where a material deficiency means a gap or inadequacy within the AML CTF program which exposes the Perth casino licensee to a risk that it will fail to identify, manage and mitigate money laundering and counter-terrorism activity. That is the focus of the theme and the task. Now, the question of the extent to which Crown Perth or Burswood nominees as the casino licensee is appropriately identifying, managing and mitigating money laundering and terrorism financing risk in connection with the gaming operations at the Perth Casino is obviously a matter of relevant inquiry for this Commission. However, to the extent the report expresses opinions about actual compliance with the AML and CTF Act, the report and evidence of Ms Waldron will not be adduced or relied on to support a contention in the Commission that Crown Resorts or Crown Perth, as Burswood nominees, is in breach of any provision of the AML CTF Act and rules. So that's essentially taking the legal question out of the scope for clarity. So when then reviewing or considering the scope of Theme 1, to be clear, the report and evidence of Ms Waldron will be adduced and relied on as evidence relating to the question of whether there is a material deficiency in the current AML CTF program, meaning a gap or inadequacy in that program which exposes the Perth Casino licensee to a risk that it will fail to identify, manage and mitigate money laundering and terrorism financing activity. And as to the first task, likewise, taking the legal question out of the framework, the report and evidence of Ms Waldron will be adduced and relied upon as evidence relating to the question of whether Crown Perth currently has an AML CTF program appropriate for an entity of its nature, size and complexity, having regard to the money laundering terrorism risks faced by Crown Perth and the profile of Crown Perth Casino, including the matters that are identified in the task, namely designated services, customer risk, country risk, delivery and channel risk. Now, given that Ms Waldron has responded to the questions as they were framed, it's necessary to clarify some of the opinions expressed to make it clear to the parties that are interested the extent to which reliance in the framework I've just placed will be put on those opinions, so that it's clear to what extent the Commission may rely on those opinions for those items I've just identified as to the underlying risk assessment. So to deal with that, because there's an element of some of these items are rolled up within the expressions of the overarching opinions, I just need to identify the relevant passages and the extent to which they're relied on.
Thank you.
So if I could take you to now pinpoint 0145, which is a summary of the findings or conclusions and opinions that are, I should say, this will become clear to already that Part A is a joint report of Ms Waldron and Ms McKern, and they each contain summaries of the opinions expressed in subsequent reports in volumes B and C. So in table 5 on that page, there's the tasks identified by cross-reference to the scope, and there is an expression of an a conclusion or opinion, and at the conclusion it says, as required under the AML CTF Act and rules. That would be received on the basis that it's expressing Ms Waldron's understanding of those requirements. And the focus is on the material deficiency, is the relevant opinion expressed based on that understanding of the requirements. In task 2, there's a reference again to not allowing it to demonstrate compliance with, it's a typographical, it should be 9.1.5. Again, that is expressing or will be received on the basis of Ms Waldron's understanding of those requirements. And this relates actually to the assessment of the enterprise-wide risk assessment methodology and approach, and it's not directly dealing with the current AML CTF program. Over the page, there's table 6, and you'll see there's a conclusion in 1. The first sentence would not be relied upon, but the second, it starts, this is on the basis that is the effective opinion. And then if I could move into volume B, which holds the main opinions discussion, you'll see there on page pinpoint 0.179, there's a slightly expanded version of the table by way of an executive summary. And in a similar manner, in paragraph 2.2.1, we would not rely on the first sentence, but on the second, on the balance of that paragraph. Would not rely on the opinion expressed in 2.2.2. In 2.2.3, again, reading the words to allow Crown to satisfy its obligations under the AML CTF Act of rules as an expression of an opinion of Ms Waldron's understanding of those obligations. It's relied upon as to the deficiency, the opinion of deficiency expressed in that paragraph. 2.2.4 is relied upon. 2.2.5 in a similar way to 2.2.3, it's relied upon as to the deficiency in the program based on Ms Waldron's understanding of the requirements of the AML CTF Act rules, AML CTF program as referred to at the conclusion of that paragraph. 2.2.6 is relied upon as the deficiency in the AML CTF program, and the balance of that executive summary section under 2.2, which is paras 2.2.7 to 2.2.10, are relied on, but they don't really address this issue. And then in the next section, which is section 3 on page 0.0183, in paragraph 3.2, in a similar way, what is relied on is the expression of opinion as to the deficiency in the risk assessment based on Ms Waldron's understanding of the requirements of the AML CTF Act and rules. And in a similar way, for paragraph 3.4 on page 0.0185, paragraph 3.4, it's relied upon as to the deficiency in the risk assessment based on Ms Waldron's understanding the requirements of the AML CTF Act and rules. In section 4 at page .0190, something's gone wrong with the paragraph numbering. There's a paragraph numbered 4.8.1. This corresponds to the table I took you to earlier, dealing with whether or not there is compliance with the requirements of Part 9.1.5 of the rules in the context of the enterprise-wide risk assessment. So again, it's relied on as to the adequacy of that assessment based on Ms Waldron's understanding of the of Part 9.1.5 of the rules. Then on page, the following page, 0.0191, just to pick this up, it's paragraph 6.1.1. There are some bullet points, and then over the page, the third starts with a view expressed about the obligations. That is relied upon as to the opinion expressed concerning the deficiency in the risk assessment, again based on Ms Waldron's understanding of the obligations under the AML CTF Act and rules. Now, commissioners will be aware that the Crown parties have provided a response to Ms Waldron's report, and Ms Waldron's provided a response to that. And if I could just take you to PCRC .0004.0012.001, where an opinion again is expressed concerning the obligations of Crown, and it's on pinpoint .0003, and perhaps the earlier page 2.0002. In that paragraph, Ms Waldron's expressing disagreement with parts of the position paper, the Crown's position paper, but the very last paragraph effectively affirms the opinion expressed, or one of the opinions expressed in the original report. And again, that is relied upon as to the deficiency in the risk assessment based on Ms Waldron's understanding of the obligations under the AML CTF Act and rules.
Sorry, Mr Fuster, which paragraph are we at now, on which page?
I'm sorry, we're on page pinpoint .0003, and at the very top of the page it says, therefore, in MW's
Yes.
opinion. Now, I've tried to be comprehensive and pick up any paragraphs in the report or the responsive document that where opinion is expressed in a way that it picks up either a requirement, compliance or obligation under the AML CTF rules, to make it clear that we're relying on it to the extent it reflects Ms Waldron's opinion, understanding of the Act and rules. If I've overlooked any paragraph that I haven't specifically mentioned, but it deals with that topic, it would fall in the general clarification I've made. But if any of the interested parties have found a paragraph of that nature or come across it, they could certainly request further clarification if there's any doubt. So that I think deals with the reliance that may be placed upon the opinions expressed in Ms. Waldron's report and responsive document. So if I could perhaps call her, if that's what I do.
Yes, thank you, Mr. Futrell. That clarifies those matters, and if there's anything the parties want to raise, they can do it at an appropriate time. So will we, is this to be taken as sworn evidence this morning?
Yes.
Ms. Waldron, do you wish to affirm or take an oath?
I'll affirm, thank you.
If you would just then mind repeating these words after me. I, Rachel Waldron,
I, Rachel Waldron,
sincerely declare and affirm
sincerely declare and affirm
that the evidence that I give to this Commission
that the evidence I will give to this Commission
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Thank you, thank you, Ms. Waldron. Mr. Futrell.
May it please the Commission. Ms. Waldron, perhaps if we could bring up the document I had before, which is PCRC.00021.001.0121. Now, you prepared a report entitled Perth Crown Royal Commission AML Forensic Report Volume A with Ms McKern of McGrath Nicol. That's correct.
Yes, that's correct.
And separately, you prepared a report. This is on pinpoint 0.0176.
Yes, that's correct.
That's a report you prepared, and you're aware that Ms McKern prepared a report. This is on pinpoint 0.0203. As well.
Yes, I'm aware of that report.
Now, in volume A, in section 5, that contains, this is on pinpoint, point 0145, a summary of the opinions and conclusions you've expressed in volume B.
Yes, that's correct.
Those opinions and conclusions are your own.
They are my own.
And are they your honestly held opinions?
I'm sorry, I couldn't hear that.
They are your honestly held opinions.
Yes, they are.
Now, the volume A contains some joint opinions or joint work of you and Ms McKern. Is that correct?
That's correct.
And to the extent that section contains opinions, are they your opinions?
Yes, they are.
And are those honestly held?
Yes, they are.
All right. Now, as to volume B, which is your report, again, are the opinions and conclusions expressed in that document your own?
Yes, they are my own.
And are they honestly held?
Yes, they are.
Is there anything in either volume A or volume B that you wish to change or modify for any reason?
No, there's one or two typos there, but no.
All right. Nothing affecting the substance?
Nothing affecting the substance, thank you.
All right. Now, can I just take you to some another document or other documents? The first is PCRC.0004.0015.0001, and I don't know if it's attached to it or is with it, but there's a document ending .0002. It may not be part of the same document.
Yes, I have those.
Now, you've been provided with copies of these documents previously,
Yes, earlier this week I've been provided with those.
okay? And have you prepared, or you've considered them and prepared a response to them?
Yes, I did.
All right. Can I show you PCRC .0004, .0012, .0001? That's the response you have prepared to the Crown Perth responsive position paper, correct?
That's correct. Yes, that's correct.
All right. Now, is there any matter raised? I'm going to take you to the document referred to as the Crown Perth responsive position paper. You know what I'm referring to when I say that. Is there any matter raised in that responsive position paper that has given you reason to change or modify any opinion or conclusion that you have expressed in either volume A or volume B of the report I've taken you to?
No, there's nothing in that responsive paper that changes the opinion that I've expressed.
And likewise, is there anything in that document that has given you reason to change or modify any opinion or conclusion expressed in the joint component of volume A of the report?
No, there is not.
Okay, now as to the document in front of you, is that all you wish to say by way of response to the Crown Perth responsive position paper?
Yes, that is.
Okay, now are the opinions and conclusions expressed in that document your own?
Yes, they are.
And are they honestly held by you?
They are.
And likewise, as I asked you with respect to the earlier report, is there anything in this particular document that you wish to modify or change?
No, there's not.
All right. Now, Commissioners, as there are no interested parties who wish to examine Ms McKern, I will tender the first report, which is volumes A, B and C, as a compendious or composite document, if that's convenient.
Just so we can keep a track of this, the document entitled Perth Crown Royal Commission AML Forensic Report, Volume A, 28 October 2021, prepared by McGrath Nicol Advisory and Murray Waldron Consulting, bearing the identifier number PCRC.0021.0001.0121. The document entitled Perth Crown Royal Commission AML Forensic Report, Volume B, 28 October 2021, prepared by Murray Waldron Consulting and bearing the identifier number PCRC.0021.0001.0176, and the document entitled Perth Casino Royal Commission AML Forensic Report, Volume C, 28 October 2021, prepared by McGrath Nicol Advisory and bearing the identifier number PCRC.0021.0001.0203, are all admitted into evidence as a composite exhibit.
May it please the Commission. I also tender the documents that comprise the Crown Perth responsive position paper, which are PCRC .0004.0015.0001 and the following document with the ending 0002.
My copies don't have the number, so that's the Alan Linklater's letter of the 8th of November.
Correct.
And the position paper, which has attached to it some materials from Pricewaterhouse.
That's right.
then those documents can go in as a single, as a composite
that
exhibit.
makes sense.
Thank you.
And I also tender the response to the response, which is PCRC .0004.0012.0001.
That document, which is headed Murray Waldron Consulting Response to the Crown Perth Responsive Position Paper and bearing the identifier number PCRC.0004.0012.0001 is admitted into evidence as an exhibit.
Now, Commissioners, there are just a couple of matters I wish to clarify with the witness before interested parties have an opportunity to examine Ms Waldron.
Sorry, Mr. Beardley. Mr. Futel, if I could just address Mr. Dharmananda for a moment in relation to the Crown position paper. It refers to some documents that have not previously been referred to. So, can we take it that Crown will ensure that those documents will be put in due course?
Yes.
Please, Commission. Ms Waldron, do you have a hard copy of the Volume A to C report? It might be easy for you to use that than trying to look at it on the screen. Could I'm assuming yours does have the PCRC numbers in the top right-hand corner?
Volume A does. Volume C, yes, it does. Sorry.
All right. So if I could ask you to go to PCRC .0021.0001.0183 and paragraph 3.3.3. Could I ask you what is the nature of the risk assessment that you consider should have been completed in accordance with the what's referred to as the ML/TF Risk Assessment and Methodology Appendix B?
I'm sorry, could you just repeat that question again?
So what is the nature of the risk assessment that you consider should have been completed?
As referred to in Appendix B?
Yes.
Yes. There's a detailed methodology which is Appendix B to the Crown's program, and it forms part of Crown's program. And that risk assessment methodology sets out the approach that Crown ought to adopt in assessing its MLTF risk, which takes into consideration a number of key factors, as it should in assessing MLTF risk, which include an assessment of Crown's customer risk, its products, the channels in which it offers its products, and the jurisdictions it deals with. And that methodology in Appendix B sets out the approach to undertaking that assessment at both an inherent and a residual risk level.
What are the steps taken in undertaking a risk assessment of that nature?
In general?
Yes.
Yes. So the Act and the rules set out that in undertaking an MLTF risk assessment, a reporting entity who has obligations under the Act by virtue of offering a designated service, must take into consideration its own size, nature and complexity. So that is provide context to the risk assessment, and it must assess those risks that it might reasonably face. And in considering those risks that it might reasonably face, the rules set out that it must include an assessment of the entity's customer types, including politically exposed persons or PEPs, the products which are offered, also referred to as designated services, the channels in which those services are offered and the jurisdictions it's exposed to. So once all of those are assessed, that gives the entity a understanding of the inherent risk that it might, MLTF risk it might be exposed to.
What do you mean by channels?
Channels are the way that the product or the designated service is offered. So that's often summarised as face-to-face or non-face-to-face, a virtual channel, digital channel, for want of a better word.
Can you give an example of a channel, just so it's clear what you're describing?
Yes, so a channel in the casino context might be a patron account, or it might be an electronic gaming machine is a channel in which a patron would be able to receive a designated service through Crown.
All right, now staying with that paragraph, why do you say there has been no documented assessment completed in accordance with that?
During the course of our documentary review, we were unable to locate any outcome of the MLTF risk assessment in accordance with that methodology. And during the course of our interviews conducted with key Crown personnel, we asked each relevant stakeholder during the interview whether such document existed, and we were advised that no such document existed in accordance with the methodology set out and forming part of the Part A program.
All right, can I ask you to turn to page pinpoint 0.0184 and paragraph 3.3.6. And in the first sentence, you've used the expression a holistic assessment of MLTF risk. What do you mean by the expression? What is the nature of an holistic assessment of MLTF risk referred to in that paragraph?
A holistic assessment would be an assessment taking into consideration all of those things that I've just outlined and are set out in the rules. And when we talk about a holistic assessment, that would be an assessment of Crown Perth in its entirety. So in understanding what that would look like, if you can imagine that you would look at all of the different types of customers, products, channels and jurisdictions that each of the relevant businesses in the casino operate and offer, and you would get a good understanding of what those are. So what the particular customer types of Crown Perth are. You would then collate all of that information and complete an assessment of the likelihood and impact of MLTF risk or Crown being exposed to MLTF risk at that entity level. In Crown's case, because they have a joint program, which means that there are multiple entities under the one program and that they have formed what's referred to as a designated business group, that risk assessment would be done at an entity level and then rolled up collectively across the three properties to form what Crown refers to as an enterprise-wide risk assessment.
Okay, now why do you say in that paragraph that the external reports that you've referred to earlier do not provide an assessment of Crown's inherent risk, likelihood and consequence control, environment assessment, change risk or residual risk assessment?
Each of the external reports that we refer to in the report and that we've been provided are targeted reports addressing specific risks or controls. So they're not what I've just outlined is required under the rules and what we would expect to see as a overall or holistic enterprise-wide risk assessment.
All right. Now, what is the consequence or significance from a risk assessment perspective of the absence of the holistic assessment in your view?
In terms of Crown being able to identify, mitigate and manage its MLTF risks, which is the primary purpose of its program, the consequences are significant because in the absence of a risk assessment, Crown is not able to satisfactorily say what risks it might be exposed to, and it cannot demonstrate, based on my experience and industry practice, what controls have been put in place to mitigate that risk. Therefore, my opinion was that it was not appropriately risk-based to mitigate the risks that Crown's exposed to in the absence of that risk assessment.
Are you able to give an example of the kind of risk that may not be identified in the absence of a holistic assessment?
In Crown Perth's example?
Yes.
I believe in the Deloitte Phase 2 report that we've been provided with, an example there has been identified as the patron accounts operated at Crown to which deposits were made have not historically been considered as a channel through which money could be deposited and potentially risks of money laundering taking place, whether inadvertently or otherwise. And so that has not previously been considered as a channel risk and therefore has not been assessed. Potentially leaves Crown exposed to the risk of money laundering through that particular channel.
All right. Now, in paragraph on page 0.0185,
Yes.
In paragraph 3.4, you've used the expression the joint AMLC must be aligned to the current MLTF risks as identified in the risk assessment, etc. What do you mean by that the alignment point in that sentence?
Well, the primary purpose of the program under the Act and the rules is to identify, mitigate and manage your MLTF risks. So the first element of that requirement is to identify risk. If you haven't done that identification of risk, having considered those elements that I mentioned earlier, customer, product, channel and jurisdiction, then you cannot say that your program is aligned to the risk assessment that you've undertaken. So the program in this instance, in my opinion, it is not aligned to the risks that Crown might reasonably face.
To move to a different topic, if I may, which is on page wrong reference, I'm sorry. All right, so this is on pages pinpoint 0.0196 and to 0.0197. You're dealing here with the topic of resources.
That's correct.
And in paragraph 8.3.2, there's a sentence that says, the first sentence refers to the annual team having been operated outside internal service level agreements. What what is the source of the information you've relied on to make that statement?
The sources are various internal management information reports that provided detail of alerts that are being reviewed outside of the 28-day service level agreement, internal service level agreement.
And when you say alerts, are they alerts by reference to transaction monitoring?
Yes, they would include transaction monitoring. They may also include manual unusual activity report that's being raised.
Okay, thank you. Now, in paragraph 8.3.8 on pinpoint 0.0197, you've referred in the first sentence to successful implementation and embedment of any change program. The first line, resources will need to have a clear understanding, etc. What is the significance of implementation and embedment of any change program for the resources associated with the first line of defence?
So obviously Crown is going through a very significant, I'd say, wholesale change program in relation to its financial crime and specifically its AML-CTF program. That's being largely driven at the moment by the second line, so the financial crime team, which is appropriately reviewing all of the different policies, procedures, standards, and the pending EWRA or enterprise risk assessment. But ultimately, the first line or the business owns the risk, and it is responsible for not only owning that risk, but making sure that the controls that have been designed in the second line are implemented in the business. That is, they can reduce the risk of potentially money laundering or terrorism financing taking place. So to do that in the context of a fairly significant change program, my opinion is that the first line resources need to both be equipped with the knowledge and awareness of those change, uplift the documents that they currently have in place, or design new documents or standards to address those changes being made, and then be able to demonstrate that the changes are being implemented. And that's generally done via assurance activities once the controls have been implemented. So that therefore demonstrates it's been embedded. The position in relation to the first line resources at Crown Perth is that they are currently operational, but are still waiting for a number of these significant changes to take place because they are still in the design phase. The first line resourcing in Melbourne and potentially Sydney when it opens, are currently not in place. They've been stood down as a result of obviously the pandemic and the delay in the Sydney opening. And so they'll need to take into consideration the different changes that have been made once those other casinos open.
Does the implementation of changes have any implications for the resourcing in the first line of defence?
It'll have an impact on the first line in terms of their time to implement those changes will take some time, and a number of the processes, such as the source of wealth form that has been recently introduced, it has an increased time effect, if you like, on the first line resources. So the increased focus on compliance, if you like, is detracting from their normal business as usual activity, which is gaming and patron welfare. Okay.
If I could go back to pinpoint 0.0196 and paragraph 8.2, where you've expressed an opinion that the existing resources are insufficient to manage Crown's current BAU activity effectively and unlikely to be sufficient to embed the change program across the three lines model. And then you set out in paragraphs 8.3.1 through and following the factors you've taken into account. Can you explain in what way you've drawn on your experience or expertise to form that opinion based on those factors?
Yes, I've worked both in industry as a compliance officer and in recent years as a consultant across many reporting entities, and understand that any change requires considerable time and effort to implement and embed in any organisation, regardless of the size or complexity. So in relation to Crown specifically, it's our view that the business as usual resourcing is currently not operating across all three properties, and yet still having difficulty in maintaining their SLAs and keeping on top of the alerts being generated at Crown Perth.
You used the expression SLA. Can you just explain what that is in long form?
Sorry. So that is those service level agreements that we referred to earlier in relation to the time that is considered appropriate to review unusual activity or transaction monitoring alerts.
Thank you, Ms. Morgan. I've no further questions in Chair.
Thank you. Mr. Futrell, are there any applications? Mr. Damananda.
Thank you, Commissioners. There are some matters that I will need to take instructions on forward as a result of what Mr. Futrell said with respect to the aspects of the report on which the PCRC will not rely, but I can do that in the break after the 1 minute silence.
Thank you. Thank you.
Ms. Waldron, my name is Damananda. I appear to Crown Interests. Can I ask you, who asked you to prepare a response to the position paper provided by Crown?
The instructing solicitors, Cause Chambers Westgarston.
And when were those instructions given?
I received the position paper on Monday evening this week, and I was asked to prepare a response to the position paper on Tuesday.
Did anyone assist you in the preparation of that response?
No, the response is largely my own. My business partner reviewed that for quality assurance purposes.
By business partner, do you mean Ms. Murray?
That's correct.
Did you share a draft of your response with anyone before it was finalised?
I shared a draft with the solicitors instructing.
And did they provide any commentary or assistance with respect to the report?
There was some feedback provided, that's correct.
And the matters in your responsive report, are they matters that occurred to you before you issued your original report?
Well, largely. I don't think there were any matters that were raised in the position paper that had not been considered, but I was directly responding to the comments in the position paper in our response.
There were matters that occurred to you before the position paper was provided to you. Why did you not include those matters in your original report?
There was no reason why I either excluded them or felt that they were required to be included.
Who do you consider your client is on this engagement, Ms. Waldron?
I've been engaged to assist the council assisting the PCRC.
Were you provided at any stage of this engagement the Federal Court guidelines in relation to the obligations of an independent expert?
Yes, I was.
And when was that?
At the time we were engaged.
Is that the letter written by the PCRC or the letter from the Government of Western Australia?
I don't believe it was. I'm sorry.
Page 150,152 of the joint report, please, operator.
I don't believe it was included in that, with that particular engagement letter.
So when was it provided to you?
I couldn't say exactly, I'm sorry. I believe I have been provided with it during the course of this engagement.
When were you originally engaged, Ms. Waldron?
Well, formally engaged pursuant to the letter that you have on screen. We were contacted some months ago to discuss our potential engagement. And then during the course of the commission, the focus was elsewhere. And so I think we were re-engaged to discuss the scope of our engagement in approximately August, September.
In August or September, you had started having dealings with counsel assisting the commission. That's
correct. I'm sorry, I had dealings with the solicitor on behalf of the counsel assisting the commission.
A member of Court Chambers Westcar.
Yes, that's correct.
So you had various communications with them since August?
I believe that would be correct.
Your report is dated 28 October.
That's correct.
But you were formally engaged on the 20th of September.
That's correct.
So were you carrying out any work during your communications with Cause before your formal engagement?
No, other than to discuss scope, there was no work undertaken prior to that engagement.
So in essence, you completed your report in about 5 weeks after your formal engagement.
That's correct.
The report has 3 parts, as Mr. Futrell identified. And Volume A is a joint report with McGrath-Nicol.
Correct.
Were you involved in preparing Volume A or just Volume B?
No, I was involved in preparing parts of Volume A.
And you and Miss Murray were the only 2 people working on Volume B.
Yes, that's. I apologise. There was some assistance provided by a staff member of McGrath-Nicol to help with triaging and documentary review at first instance.
What do you mean by triaging?
Well, there was some 350,000 documents provided to us, and as a result, we needed to do certain word searches for the relevant documents that were specific to our scope. So we utilised the services of a McGrath-Nicol staff member to help us do that, to identify those relevant documents that we had requested and that had been provided pursuant to the notice to produce.
So you say you were provided with 300,000 documents. Did I get that right?
They are I believe that's the number of documents that is in the document repository, electronic repository system. I certainly haven't been provided or reviewed all of those documents.
You were the lead author of Volume B?
That's correct.
Did you have other engagements during the time of this engagement?
As in other clients?
Yes.
Yes, I did, yes.
So you did not work exclusively on this report?
A large part of my time has been spent on this particular matter, but I have had other engagements, yes.
Can I get a sense of how many hours you work on an average day?
It would vary, but this particular matter has taken up quite a considerable amount of my time, and quite lengthy days, including weekends, as you would expect.
8, 9, 10 hours?
I couldn't give you a definitive time, but most certainly my usual day is between an 8 to 10 hour day. And there have been days where I have worked longer in this particular matter, particularly of late, as the report was coming due, and since the report was submitted on the 28th, yes.
Ms Waldron will just break now for the commemoration, and as is customary, we'll observe a minute's silence to commemorate and recognise the sacrifice that countless people have made in the service of their country. So if we would be silent for 1 minute, please. Thank you, thank you. You'll be pleased to know that I overlooked engaging a bugler to pay the last post. Thank you, Ms Waldron, Mr Dharmananda.
Commissioners, I don't know whether you wanted to
Oh,
break
yes,
now.
we will.
Yes.
I think it probably is
Yes.
sensible. We'll break for 20 minutes and come back. We'll come back at 11:20 our time. That's 2:20 your time, Ms Waldron. Thank you.
Thank you.
All rise.
Ms Waldron, Mr Damananda.
Thank you, Commissioners. Ms Waldron, before the break, you informed us that you were aware of the Federal Court practice direction concerning experts. Is that correct?
I am aware of it, yes.
You're aware that that practice direction requires a person called upon to give expert evidence to record and acknowledge the existence of the direction and say that the expert has complied with it. Are you aware of that?
I am aware of that. And during the break, I also just reflected that I may not have received that code as a result of this particular engagement, but I have received it in relation to other engagements of which I've been engaged as an expert. I do recall that I have been asked whether I was familiar with it, and the answer to that would be yes, but I cannot say that I have received that. If you have a copy of it as a result of the engagement that you could show me, I'd be grateful. But during the break, I wasn't able to locate it in my files.
Ms Waldron, we don't have copies of the communications you have had with cause, none of them. So I'm informing you that the direction requires you to acknowledge the content of that direction when you file an expert report. You're familiar with that requirement?
I am familiar with that requirement, yes.
Your report does not have that, does it?
No, it does not.
Before the break, you mentioned that you received feedback from cause in relation to your response to the Crown position paper. Do you recall that?
I do.
How did that feedback come to you?
I had a conversation with counsel and the solicitor instructing yesterday afternoon, and it was in relation to initially two documents that were referred to and provided as a result of the position paper and a notice to produce. I had not seen the unredacted version of one of the reports, and Mr. Yates brought that to my attention.
Was there any other feedback provided to you?
There was some feedback provided later in relation to one element of the responsive paper, which dealt with paragraph 11 of Crown's responsive position paper.
Was that feedback in writing or orally?
No, we just had a telephone conversation.
Did you keep a note of that conversation?
I have kept a note. I'd sent an email in relation to that conversation.
I call for that email to be produced, Commissioners.
We note the call.
Ms Waldron, before the break you mentioned that you had the assistance of someone from McGrath-Nicol to undertake searches of the documentary database. Do you recall that?
I do.
What were the keywords used for the purposes of their searches?
They were words that we had included in the notice to produce that related specifically to the scope of our engagement. Examples of that would be MLTF risk assessment, AML-CTF program, management information and the like.
Is there a record of the keywords that were deployed for the purposes of conducting these searches?
No, I believe that we had a telephone conversation with the staff member at McGrath-Nicol who was assisting us, and we requested that certain binders be set up in the Nuix document tool that we were given access to for the purpose of this engagement.
What was the documentary tool that you were given access to?
It's Nuix. I think it's called Ringtail.
Thank you. I'd like to understand the work that you performed in the 5 weeks or so that you were given from your formal engagement. You conducted or participated in a number of interviews.
Yes, that's correct.
You reviewed documents that were received or made available to you.
That's correct.
You wrote the report together with Miss Murray and McGrath-Nicol, including the exchanging of drafts with respect to the report?
The exchanging of drafts, I believe we provided a draft report and then finalised that report the subsequent day.
So I'd like to explore each of those activities. Before I do, were there any other activities you completed with respect to the task entrusted to you by your scope of work?
No, I think they were the main activities.
So, in relation to the interviews, in volume A at page 143, we go to that please, 0143 internal numbering operator.
Yes.
You're working from a hard copy, Miss Waldron.
Yes, that's right.
That's perfectly fine. So if you see there, there's an identification of the interviews that were conducted, and the ticks represent those that you attended or Murray Waldron attended. Those are the orange ticks. Is that correct?
Yes, that's correct.
And by my count, there were 21 people interviewed, spanning over a period of about 8 days. Is that correct?
I haven't done the precise calculations, but I will take your word for it.
And I presume that you would have prepared for each of the interviews.
That's correct.
And after the interviews, did you have either an occasion to reflect on what you learnt or have a session debriefing with Ms. Murray if she attended the interview?
Generally, that is the way that we work, yes.
And who was involved in the selection of the Crown employees that you actually had the interviews with?
Ms. Murray and I identified those employees that we wanted to speak to for the purpose of our scope. McGrath-Nicol identified those that they wanted to speak to for the purposes of their scope. And where possible, we interviewed them together to avoid any duplication and obviously being more efficient with the person being interviewed or persons.
Did you have any regard to your scope in terms of considering whether you should interview someone from internal audit?
No, I didn't.
You didn't attend all of the interviews, did you?
I believe I attended all of the interviews that have a tick against them for Murray Waldron Consulting attending, yes.
But some don't have a tick for Murray Waldron and you didn't attend those?
No, that's correct.
And you received notes in respect of those meetings?
No, I did not.
If I could take you please to 128 internal numbering.
I'm sorry, what was that number? I just missed it.
0128. At paragraph 1.4.2, can I ask you to read that to yourself?
Yes.
So, set results of interviews were shared with you. Do you see that there's recorded? So those notes were made available to you, Ms. Waldron.
They were made available in the draft report that I was provided from Ms. McKern. I didn't receive any ongoing notes of the focus groups and the like.
I see. Did you, in the course of the interviews, ask any of them to walk you through the underlying AML, CTF related systems, policies, procedures, and controls?
We discussed multiple systems and controls during some of the interviews, and we walked through the AML program and the attached policies and procedures in detail with Mr. Blackburn in particular.
With Mr. Blackburn only?
Correct.
Or in particular?
No, the program in particular, and for each of the relevant personnel at Crown who were identified as being the key person for other elements of the program, such as the transaction monitoring, the assurance, KYC, and so forth. We talked in detail with those particular personnel in relation to those aspects that they were responsible for.
You say that the documents made available to you numbered around 300,000. Is that correct?
I believe that's what's in the database, yes. So they weren't all made available to me. I had access to them. They covered a wide range of issues related to both McGrath-Nicol and Murray-Waldron scope. So not all of them were relevant for my inquiries.
And when you say your inquiries, did you divide up the task of documentary review with Ms. Murray?
No, sorry, I meant the scope of our Murray-Waldron's inquiries being task one or theme one, I think, and the underlying task that Mr. Futrell took us through at the outset.
Did you, therefore, have sole responsibility for documentary review, or did you share it with Ms. Murray insofar as the scope for Murray-Waldron was concerned?
I had the predominant responsibility for reviewing all of the documents as I was responsible for writing the report.
Can I show you, please, a list of documents at CRW.701.011.1819.
Yes, I've got that.
So this is a listing of documents provided to us by counsel assisting the Royal Commission as the list of documents made available to the AML experts engaged by them. Are you familiar with this list?
I have seen this list, yes.
There are 20,000 or so documents listed in this list.
I believe that's correct, yes.
And you say you had access to 300,000 more documents, do you?
No, I'm just going off the number of that's in the document, electronic document system. And that might be pages for all I know. So I apologise if I've misled you in that regard, but there was a significant number of documents.
And not all of the documents were received at the outset of your engagement on 20 September. That's correct, isn't it?
Yes, that is correct. They came through at an iterative basis.
NTP 078, which was issued on 14 October, sought, among other things, appendices to the Phase 2 Deloitte report, the final version of the EWRA, and do you know when those documents were produced to you?
I couldn't tell you off the top of my head, no.
Would 18 October sound about right?
It's yes. Well, I'm just having regard to the Phase 2 Deloitte report, and that's dated the 15th of October. So I couldn't tell you what the date was, but it's possible it was the 18th since that report was published on the 15th.
So you had a short amount of time to get across quite a large pool of documents, Ms. Waldron.
Yes, that's right.
You did not have as much time as you would have liked.
No, I wouldn't necessarily say that.
When we look at Appendix B, which is at page 0143, there's a reference to the activity of document review in the first line item. Do you see that?
Yes.
And then there's a reference to Appendix B. Do you see that?
Yes, I do.
Can I ask, please, operator, to call up CRW.701.011.1818? Is this Appendix B, Ms. Waldron?
Is this the same document that you just shared with me before being the
No.
list? It's a different, no, I'm not sure if this is Appendix B, I'm afraid.
Operator, will you be able to scroll down the page? Did you create Appendix B, Ms. Waldron?
No, I did not.
Who created Appendix B?
I'm not sure, is this Appendix B that you're showing me here?
As best as we can understand, it has 65 documents listed.
No, I don't believe I've seen this document previously.
So when you refer in your report to refer Appendix B, to what are you referring?
We had intended to create a list of all documents referred to in the short space of time that we did have in the week that the report was due. That document list was provided by Cause Chambers Westgarth to Allens, taking into account the documents that were referred to in both the McGrath-Nicol and Murray Waldron Consulting reports as referenced by footnote.
So this is just a listing of documents identified in the footnotes.
As I said, I'm not the author of this document, so I couldn't say.
So in your report, at page 0143, you refer to Appendix B. Do you see that?
I do.
As the repository of the data relevant to your document review. I would like to know which documents you reviewed. Where do I go to find that?
All the documents that I reviewed are footnoted and referenced in either Volume A, to which I was a part author, and all of them in Volume B. They are all of the documents that I had reference to for the purpose of my report.
So can we proceed on the basis that you examined the documents identified in the footnotes to Volume B?
You can, yes.
And any documents referred to in the footnotes to Volume C, you may not have reviewed?
I may not have, correct.
Did you at any stage ask anyone from Crown to put together a set of relevant materials or documents for the purposes of your completion of the task?
No, I believe we identified relevant documents based off all of the individual tasks. We provided that to the solicitors instructing, and they then made that available to Crown via their solicitors through the notice to produce format that was agreed protocol.
What I'm trying to get at, Ms. Waldron, is whether you ever asked Crown to put together a list of relevant documents as it pertains to your task.
Yes, so as I just mentioned, we went through the tasks. I don't believe that the scope or the task document was provided to Crown via its solicitors, but in seeking to respond to each of the tasks in our scope under Theme 1, there were key documents that we would have expected to see. They were included in those documents that we requested be sought through the notice to produce channel.
You note in your report that Crown received expert AML reports from Promontory, Deloitte and Initialism at 3.1 of your report. We don't need to go there. Do you recall that?
I do.
Those are detailed reports that have been professionally prepared by reputable consultants. Do you agree with me?
I do.
Did you study them in detail?
I did.
You have what you describe as 11 tasks to complete, and that is at paragraph 1.2, appearing at page 0178. Do you see that?
Yes.
How are these divided up between you and Ms. Murray?
As I mentioned before, I had primary carriage of looking at all of the documents because I was to be the author of the final report. However, we both attended most of the interviews, not all. Ms. Murray was unable to attend some of those interviews. And Ms. Murray also reviewed some of the external guidance and typology papers, such as AUSTRAC's guidelines in relation to junkets, FADF, and other relevant reports.
So you really held the pen for the bulk of this volume B, Ms. Waldron.
Yes, that's correct.
So the burden was heavy on you.
Well, I mean, it's a significant piece of work in a short period of time, which I think is what you're getting at, and I would agree with you on that matter. I don't see it as a burden. It was something that we were engaged to do, and we had a limited time to do it.
When did you provide your initial draft to cause?
I believe it was on the 25th, if I'm not mistaken.
The 25th of October.
Oh, I'm sorry, of October.
And did you receive feedback in relation to your draft?
No, I don't believe I did. I can't recall that I did anyway, I'm sorry.
Now, by my count, you had 37 total days from the date of your instruction to the date of the delivery of your report. And if you take out the weekends, you had 27 business days. Does that seem about right?
I would take you for your word in terms of the calculated days, yes. I haven't done that calculation myself, but I'll rely on you.
Thank you. If we factor in the time spent in preparing or attending interviews, that leaves about 20 days.
That might be right.
And this has given rise to some limitations and disclaimers as contained in Volume A. If we go please to 0129. (1.5.2a), it's recorded that the following limitations may have impacted the forensic review. The first is the time available to undertake the scope was limited.
I would say that was more applicable to the McGrath-Nichols scope of work. Their scope was significantly greater than ours, and they were doing a lot of data analysis and focus groups. So in my opinion, that is an accurate statement. However, it would be more relevant to the Volume C report from McGrath-Nichols.
You don't introduce that qualification in writing here, do you, Ms. Waldron?
No, I have not.
And then at 1.5.2a, little Roman 2 in brackets, you'll see the last sentence where it's recorded that where it has not been possible to fully investigate and or resolve queries with Crown personnel within the reporting deadline, the effect of such a limitation is addressed in context within, that should be within the forensic reports.
You're right.
Yes?
Yes, you're right.
And
That is correct.
we've noticed some of those qualifications in McGrath-Nichols' report. We don't seem to find the same ones in your report. Have you made similar qualifications in your report?
No, not necessarily, because we were able to ask and have answered the predominant question that related to our scope, which was effectively looking at the November 2020 AML CTF program and the associated documents. So there was no such limitation required. We were told that certain documents either existed or they didn't exist.
We look at the limitation 1.5.2b, You see there, a further limitation is a concern that the information that you hold may not be in its final or most up-to-date form. Do you see that?
Yes.
So those limitations are relevant to both you and McGrath-Nicol.
That's correct.
Do you feel confident, Ms. Waldron, that your ability to investigate and draw conclusions were unaffected by the time that you had to complete your scope?
Yes, I felt that the conclusions drawn were able to be done so in the time available.
All right. Well, let us go to your scope, which is at 164.
Yes, I have that.
Now, you'll see immediately, Ms. Waldron, that there is red text which says draft for discussion. Do you see that?
I do.
Who prepared this document?
It was prepared jointly between McGrath-Nicol and Murray Waldron Consulting. We inputted into the theme one, but it was ultimately consolidated, if you like, by McGrath-Nicol and provided to the solicitors.
Was the draft discussed?
I believe the draft was discussed, yes.
With whom?
It was discussed with the solicitors instructing from cause.
So, did the discussions with cause lead to any amendment with respect to your scope?
No, I don't believe it did. I think, if I recall correctly, the scope was as prepared, and it then went to the final approver, of which the name of the agency and the government escapes me, but is in the letter that you showed me earlier.
When was that discussion?
Well, there were emails. I don't believe there were telephone. Well, there might have been telephone discussions. There were a number of different versions of the scope in which we and McGrath-Nicol were attempting to ensure that we were able to address the questions being asked by the Commission and do so in the time available to us.
Was that discussion before or after 20 September? Do you know?
I don't know off the top of my head, no, sorry.
Was it before or after you were engaged?
It was before we were formally engaged.
So before you were formally engaged, you were having discussions with cause about the scope of your work.
We were trying to settle the scope document, that's correct.
And the scope was never finalised.
Well, it does refer to draft for discussion, but we have worked off this as the final scope document. This is what was returned to us with the version. It says final. Sorry, I should clarify that. In the when it was returned to us, it does still say draft for discussion. It was saved as draft for discussion final. And that's the document that we have been working on. It was just an oversight that the draft for discussion wording is still included in that document, I'm afraid.
So you have applied yourself to discharge all of the steps identified in this draft for discussion scope.
Yes, that's right.
Now you'll see within the first black box there's a definition of material deficiency. Do you see that?
I do.
You'll see that it adverts to a material deficiency, meaning a gap or inadequacy within the AML-CTF program, which exposes the Perth casino licensee to a risk that it will fail to identify, etc. Do you see that use of the language of a risk?
Yes.
Does that refer to any level of risk exposure?
No, I was looking at it from a purely money laundering, terrorism financing risk perspective. That was the scope of my work.
But that's not what your scope says. It identifies a risk, does it not?
That is the wording there, yes, that's right. But I've been engaged as an AML CTF expert, and so that would be the limitation of the opinion that I'm expressing.
So let's go then, please, to page 178. You'll see that this is your report where you identify the scope and the approach, and relevantly, there is a reference in 1.1b to any material deficiency. Do you see that?
Yes,
And that is defined at the bottom of the page in exactly the same terms, which refers to a risk that it will fail to identify, manage, and mitigate its money laundering and terrorism financing activity. Do you see that?
I do.
Are you telling the commissioners that you did not apply that standard?
I applied it in the context that I was engaged as an AML CTF expert, and I think that's fairly clear from the report. An interpretation I see that you made could be made, but the engagement as an AML CTF forensic expert, I would hope would qualify what my range of expertise was, and the opinion being provided.
What I'm asking you, Ms. Waldron, is to deal with the definition which appears to equate any risk with a material deficiency, any risk at all, because it uses the language of a risk. Do you see that?
I do.
So there's no concept of residual risk accommodated within the definition.
I'm not sure I understand your question, sorry.
How do you reconcile the use of that definition with what is stated at page 135? At paragraph 3.5.1. It stated there, no entity or organization is free from risk. Did you see that?
I do.
On that definition, does that mean that no entity is not materially deficient?
No, it doesn't mean that. It means that every entity or all entities would be exposed to some level of risk. And in the context of my report, we're referring to money laundering, terrorism financing risk. And what I'm saying is that there should be no expectation that any organisation is free from any level of risk or a level of risk.
But you have deployed the definition of material deficiency throughout your report, have you not?
Yes, I've sought to, yes.
And that definition carries with it a reference to any risk as being materially deficient. Do you accept that?
I could see how that it can be read to be the case, yes.
So how then are we to read your report, Ms. Waldron, wherever that expression is used?
In the
Given it has
context
a
of,
defined meaning.
it's in the context of money laundering, terrorism financing risk.
So
It clearly doesn't address all risks that an organisation might be exposed to.
So are you then making the point that any level of money laundering risk is a material deficiency?
No,
You're not.
I'm not making that.
But you're using that expression in your report repeatedly.
I'm saying that the way that the opinion was provided was that a material risk would have as defined, exposes the casino licensee to the risk that it will fail to identify, manage and mitigate its money laundering, terrorism financing activity.
That's not how the definition reads, Ms. Waldron, does it? Because it refers to a risk.
Well, I have applied that definition in the context of their casino being unable to identify, manage and mitigate its money laundering and terrorism financing risk. So I think the subsequent limitation that I've applied at the end of that sentence related to MLTF risk clearly defines the terms that I've been asked and given an opinion on.
Who provided the definition of material deficiency?
I can't recall right at this stage, I'm sorry.
Is it one of your definitions that you use?
No, it's not a common definition that I would normally use in the context of my work.
Thank you. If we return to the scope document, at 164, you see the scope has tasks and it also refers to steps, and it is numbered down to 11. Do you see that?
I do.
In the body of your report, you call each step a task. So you have 11 tasks. That's correct, isn't it?
That's correct.
I wonder whether you'd be able to help us reconcile the scope with the report, or the body of the report. So if you look within your report at page 200, about the middle of the page, there's a reference to task 11. You see that?
Yes, I do.
Now, returning to the scope document, page 165, how do we get to task 11 as contained in the body of the report?
That relates to step 11, if you like, which is on the last page of the scope document. It relates to review and evaluate the processes employed by the casino to detect and report potential and other serious crimes.
Ms. Waldron, my 11 on page 165 is blank. Does your 11 have something else in it?
Yes, it does.
The copy on the screen that the PCRC has been provided is also blank.
Yes, I see that now. I'm reading off the document that was in the report that I had in front of me. I'm sorry, I didn't realise that it was blank on the screen, but I can see that now.
So we don't know the scope to which you are referring, Ms. Waldron.
I think there's obviously a page missing.
What is this document with which we are dealing if it's not the document that you have been working from?
Well, I would say it is the document that I've been working from, but there is a page missing or the reference to task 11.
A page missing. Do you have an additional page with you, Ms. Waldron?
Well, my number 10 is at the end of one page and 11 is at the beginning of another.
So this is not a final version, Ms. Waldron, that we are now seeing in this report that has been filed with the PCRC.
It appears not to be.
So we're dealing with a draft labeled draft, but also a superseded draft of your scope.
I don't believe it would supersede it. From looking at it, I believe that there might just be something that is missing off that particular version.
Ms. Waldron, do you have a copy of that report, and does CORS have a copy of the report that you hold in your hands?
Yes, I took this from the. I believe I'd taken it from the appendix in the consolidated volume A, B, and C.
I call for that report, Commissioners.
The call is noted.
Ms. Waldron, returning to page 200, you'll see that the tasks reported as task 11 seem to be really tasks 9 and 10 on my version, if you look on the screen.
I will go off your version.
So task 11 is really task 10, and when you go to page 202, you state, with respect to the assessment of UAI compliance with the program, you say that at 11.3.2, due to timing constraint during the review, we were unable to obtain the relevant outputs on which to conduct this assessment, and as such have not been able to provide on this matter. So you can complete that part.
That's correct. That about information from McGrath-Nichol, to which we were to receive the information, hadn't been completed by the time we'd finalised our report.
If we look at tasks 8 and 9 at page 198, do you see those tasks, Ms. Waldron?
I do.
That appears to compare, and you compare that with tasks 8 and 9 of the scope.
I'll just wait for the scope document to come up if I could.
Task 8 and 9, as described on page 198, appears to be step 7 of the scope, although some detail is dropped. And the second bullet on page 198, if we go to that, it says, assess Crown's, there should be an apostrophe there, AML CTF risk awareness training program to determine if they're appropriately risk-based given the MLTF risks faced by Crown. Do you see that second bullet on that page?
Yes.
We return to the scope page, 164 and 165. Can you tell me where that task is identified in the scope?
Looking at your document, I am yes, I think it's clear that we're working off a different document here, I'm afraid.
So that is not part of the scope as contained in the report provided to Crown and to the PCRC.
It appears not to be, based on the document on the screen. It is slightly different to the document that I have and have had as final during the course of my review, which included an assessment of the AML CTF risk awareness training.
If you look then to task 10 in the body of the report at page 199, which is recorded as assess whether Crown's transaction monitoring program includes appropriate risk-based systems and controls to monitor customers' transactions. Do you see that?
I do.
And that seems to be step 8 in the scope document that we have at page 165.
Just wait for the scope document to come back up. If
Certainly.
that looks correct, yeah.
So, Ms. Waldron, you'll agree with me that a comparison of the scope and the body of the report reveals there's a bit of mess there.
I believe that there's a more up-to-date version of the draft, that the one that is being included in the final report. You're correct.
And
I'm
was
very
that-
clear on the scope of my work, but unfortunately it's not reflected in that final version of the document that you've received and the PCRC has in front of them.
And was that a result of not enough time to complete your task, do you think?
No, it wasn't. I believe it would be an oversight.
You provided a high-level CV at report page 171. You're aware that Crown, by its instructing solicitors, asked for a more detailed CV for you.
I am aware of that, yes.
Are you aware of why that request was rejected?
Well, it wasn't rejected. I have provided a more detailed CV to the instructing solicitors yesterday, and it was our view that given we're not a witness in this matter, we're an expert, that I did not need to necessarily set out all of my detailed roles and responsibilities. I'm happy to take you through those.
So, as an expert, you feel that you don't need to reveal details of your experience and your prior engagements?
I believe they're adequately set out there.
You founded Murray Waldron Consulting in July 2018,
Yes, I co-founded.
and you've adopted an alphabetical approach in the sense that Ms. Murray's name comes before yours, although you are the most senior person.
There was no real logic to it, but thank you. Senior in years, perhaps.
And before you started Murray Waldron, you were at ANZ for about 3 years
That's right.
in an AML CTF role.
An AML CTF role as well as Head of Operational Risk and Compliance.
And before that, you were at NAB for about 9 years, again in an AML CTF role.
Yes, also in roles in Group Compliance and Group Assurance.
And did you cross over with Mr. Neil Jeans at that time?
I certainly did.
And he presented to you as a capable and professional person in the AML scene?
He certainly is.
Before NAB, you had roles with ASIC and the public prosecutor that did not involve AML or CTF.
No, that's right. In fact, the Act hadn't even been passed back then. I predate it.
I'd like now to take you through certain of your findings in the body of your report. We begin, please, at B3, which is at 164. Sorry, I just want to understand the scope of work before we turn to your body of your report. So the scope, or certainly the scope we have at 164, identifies 4 matters relevantly to the assessment task entrusted to you within the first box. Do you see that?
I'll just wait for it to come up if that's all right. Now, would you mind repeating the question? Sorry.
So I'm just addressing you on the first box, if you like, which is assess whether Crown is subject to a compliant AML CTF program appropriate for an entity. So that box has within it 5 steps. I want to deal with the first 4. So operator, it's the other, it's the steps, and that's what I'm up after. Thank you. So the first step, Ms. Waldron, is set out as requiring you to determine the basis upon which Burswood asserts that the joint AML-CTF program is risk-based as required under the AML-CTF Act and rules.
Sorry, Mr. Tamanani, you said you're going to go to 4, so I think we should have the next page as well.
Thank you.
So that all 5 are on the screen.
Thank you, Mr. Commissioner.
I see both of those, thank you.
So step 1 required a determination of the basis upon which Burswood asserts that the joint AML-CTF program is risk-based. Do you see that?
I do.
Step 2 is to determine and assess the methodology and status of the enterprise-wide risk assessment proposed under the FCCCP, which is to be completed by December 2021. See that?
Yes.
Step 3 is requiring you to identify AML-CTF risks faced by casinos generally and by Perth casinos specifically based on risk reviews and registers, research as to AML-CTF risks in casinos, and ML incidents identified in the Bergen Inquiry in the Victorian Royal Commission. Do you see that?
I do.
And following through that sequence, you then proceed to step 4, which is to review the adequacy of the current joint program approved by the board in November 2020, having regard to A, the risks identified by Crown relevant to Crown Perth. That's A. You see that?
Yes.
B, the risk-based systems and controls introduced subsequent to the approval of the joint program. You see that? So that requires attention to systems and controls. And C is the task calling for your opinion. And do you see that, Ms. Waldron?
I do.
So the exercise is to look at various aspects of Crown's operations in steps 1 to 3 before forming a view as to the adequacy of the program in step 4.
Yes.
And it is a sequential process.
Yes, that's probably correct, yes.
So if we then turn to section B3 at page 182, you set out your understanding of the basis on which Crown's joint AML program is said to be risk-based at 3.1. Do you see that?
Yes, I do.
And you call that the 2020 framework.
Yes, that's my terminology, just to be clear.
And that seems to answer step 1. Would you agree with me?
Yes.
You then proceed at 3.2 and throughout the balance of the section to express a view on compliance with the AML-CTF legislation. We look at 3.2, you state, it is our opinion that the 2020 framework does not enable either Crown Perth or the group collectively to assert the joint AML-CTF program is sufficiently risk-based as required by Section 85.
Yes.
Chapter 9 of the rules. Do you see that?
I do.
That seems to be skipping to step 4.
Not necessarily. It's providing a view in relation to the what I have referred to collectively as the 2020 framework.
Are we to assume that you've considered your conclusions in steps 2 and 3 when you address step 1?
Would you be able to bring up the scope document again so I can just confirm that?
Yes. 164, please, operator.
Thank you. No, I'm comfortable in having formed the opinion expressed in 3.2 based on the framework itself. And I don't think that I have missed anything. Step 2 in particular talks about a future state being the enterprise-wide risk assessment, and step 3 looks at the risks faced by casinos generally and Perth, as you can see there, and that were included in the relevant risk registers which we were provided, and the research that we had regard to either ourselves or from other relevant experts who have given an opinion and in detail set out what typologies are relevant, MLTF typologies are relevant in the casino sector, as well as those incidents identified by the Bergen inquiry. So I don't believe that I have skipped any steps. I feel like I'm comfortable with the opinion provided based on an assessment of the 2020 framework.
You'll see that step 1 required you to determine the basis upon which Burswood asserts particular things. Do you see that, Ms. Waldron?
I do.
In the scope that you settled upon. Did you at any stage seek to ask Crown to make that assertion?
Well, they rely on the program as being a compliant AML CTF program, so one would assume that that's an assertion that they're making.
You use the word "one would assume," so is the answer to my question that you never actually asked Crown to make the assertion?
During interviews, in fact, we were asking personnel that we interviewed, in particular Mr. Blackburn and Mr. Sutherland, who is involved in the MLTF risk assessment stream, whether they thought that the program, whether it was their view, I should say, that the program of November 2020 approved by the board was in fact risk-based, and it was their view that it was.
So during the glare of an interview, you orally asked certain questions with respect to this matter, but never asked for a comprehensive assertion from Crown in respect of what it asserts constitutes the joint AML CTF program being risk-based. Is that correct?
Well, we certainly asked, in addition to the interview questions, we asked for all those documents that Crown Perth and Crown DVG, if you like, relied on to say that the program was risk-based. So in asking for those documents, I would assume that they provided me with all of the documents on which they rely and which I can form that opinion.
Where do we find that request, Ms. Waldron?
It forms the basis of the notices to produce, and there were various number of them, I believe.
Which ones?
Which ones? Which ones in particular?
Yes.
I'd have to have a look at all of them. I don't have them sitting in front of me, I'm afraid. But the original request would have included all of the documents that we were seeking to obtain in order to address our scope.
We may be breaking for lunch in about 40 minutes. Can I ask you during the adjournment to locate the relevant notices so that we can be informed about that? Because it's not in your report, is it?
No, it's not referenced in my report. It was, we relied on the solicitors instructing or assisting the Commission to send those notices to produce. And so they were not my documents themselves.
No, I understand that, Ms. Waldron. I'm just trying to understand which notices to produce you say constitute completion of step 1. And if I could ask you to see whether you can locate them over the adjournment when we get there, that would be helpful to us.
I can make those inquiries.
Of whom would you make the inquiries, Ms. Waldron?
With the solicitors instructing us.
That may be a difficulty. We'll get to that. If I could now ask you to look at paragraph 3.2 again.
Yeah.
And your conclusion there expressed. And do I take it from reading your report that that conclusion arises because, in your view, there is no documented and holistic risk assessment, which you say is required by the AML CTF Act and rules?
That is correct, based that the November 2020 AML program is based on.
And so that's elaborated on in your report sent to us last night at paragraph 9.
It's also elaborated on in further on in our report, where we make reference to a number of different risk registers and documents that were provided as a result of our inquiries, or our request to produce documents from 3.3.4 and 3.3.5 onwards, or included in those particular paragraphs, I should say.
But to get to the gist of your view, is it correct to say that the heart of your complaint is the absence of a standalone document or similar documents?
Well, firstly, it's certainly not a complaint. It's a requirement, in my opinion, under the rules, to be able to demonstrate that you have assessed your MLTF risk. If Crown had been able to produce even a consolidated review of different risk factors that were required to be considered as part of the November 2020 program, I would have been more than happy to have considered those as the MLTF risk assessment if they'd followed the Annexure B methodology. But unfortunately, they were not provided to us. And so that is the reason that I formed the opinion that the AML program was not sufficiently risk-based.
Sorry, Mr. Darmand, was the reference in the responsive report to paragraph 9?
Yes, Commissioner. You've seen Crown's position paper.
I have, yes.
Particularly at paragraphs 10 and 11, where Crown sets out its position that the AML CTF Act and rules are silent on how risks should be assessed and do not define what risk-based means. You recall that?
I do recall that, yes.
And you've responded to this further in your later report of last night. Have you not?
I did, yes, that's right. I've responded to those particular paragraphs.
But you'd agree that these matters reflect a legal conclusion resting on a particular interpretation of the requirements of the AML CTF Act and rules?
No, I don't agree with that. I'm not expressing a legal opinion. I'm expressing an opinion based on my experience, both practicing over a number of years in reporting entities and having been required to write a program and undertake a risk assessment. I've also based it on my understanding of the legislation based on my experience in industry and as a consultant, and also with my engagements with AUSTRAC and reading their guidance, feedback and various enforcement actions which relate directly to this particular point. So I do base the disagreement I have in relation to Crown's position paper at 9 and 10 based on my experience.
What I'm asking you is whether you agree that there is a question of statutory construction relevant to this particular aspect of the opinion that you have expressed.
It's an interpretation of the rules.
And that's not statutory construction?
Well, you could call it that if you like. I'm very cautious of not entering into a legal discussion as I am not practicing as a lawyer, but certainly it is a interpretation of the rules that require any reporting entity to set out how they have assessed their risk. And that is set out in Part 9 of the rules. And it sets out quite clearly what reporting entities are required to take into consideration in assessing those risks. So it tells you what to consider, it doesn't tell you how to do it. So Crown could do it however they like. They have documented that in Annexure B, and unfortunately we weren't able to see anything that demonstrated that they have considered the issues in the rules or Annexure B to the satisfaction that led me to the opinion that the program was not sufficiently risk-based.
Ms. Waldron, you heard Mr. Futrell this morning abandon reliance on various parts of your report.
I heard him qualify it, yes.
Qualify the reliance? What did you understand Mr. Futrell attended to this morning?
Well, I understood that he was saying that the Commission should not consider my opinion in relation to a breach of the Act or the rules. The word abandon is yours, not mine.
Turn please to paragraph 3.3.6, which is at page 184. Ms. Waldron, just to check, does the body of your report also have changes as are reflected in the scope? Have you checked that?
I'm sorry, I don't understand your question.
So we've now identified during the course of this discussion that the document that presents as a scope for you is different to the document that presents as a scope for us. I now want to be sure that in terms of the report itself, we are dealing with the same report, or whether there has been another error with respect to that report.
No, we're referring to the same report based on the PCRC identification number. So I am looking at 0.184, and I think you've asked me to refer to 3.3.6.
Yes, the problem for us is that the scope also has a PCRC identification number and a page number.
I understand that.
At 3.3.6, at page 184, you acknowledge the various experts' reports from the likes of Initialism, Deloitte and Promontory. Do you see that?
I do.
But then you say that they do not provide an adequate and holistic assessment of the risk faced by a casino. Do you see that?
Yes, I do. Or in accordance with the MLTF risk assessment methodology at Annexure B of Crown's program.
Regardless of your view of what the Act and rules demand, an assessment of Crown's position, as asserted for the purposes of Step 1, would require you to consider those expert reports. Do you agree with me?
I do.
Did you consider those reports?
I did.
You mentioned some analysis of the reports in your reply sent last night at paragraph 15. Do you see that?
Yes, I do.
Where do I find your consideration of these expert reports in your first report?
I've just included in the paragraph that you've referred me to there in relation to the issue of whether or not they constituted an MLTF risk assessment.
So
my view is that they do not.
Is it fair to say that in your first report, you do not identify with any particularity matters of deficiency or inadequacy in those expert reports?
No, in fact, I don't disagree with those expert reports, but we've been asked a very different question to the scope of those particular expert reports. My scope and the question was in relation to whether or not the current program, the November 2020 program, is risk-based. And that is not what, in my opinion and my understanding, based on the engagement letters and the the final reports of those relevant experts. That is not what they've been asked to do. So we have a slightly different remit.
All right. I wonder how you reconcile that with page 180. I beg your pardon, page 190, and your conclusion at paragraph 5.1. Now, you'll recall that task 3 or step 3 was to identify the AML CTF risks faced by casinos and by Crown Perth.
I do.
And in response to that, you state at 5.1, the AML CTF risks and typologies faced by casinos, there should be no apostrophe there, have been well documented in external reports, including the Initialism, Deloitte, Promontory and McGrath-Nicol reports. Do you see that?
Yes.
So, in answer to task 3, you begin by pointing to the external reviews. Do you see that?
I do, which set out in very extensive detail the typologies related to casinos for MLTF risks. So, in the interest and time and brevity, we did not repeat all of those in our report.
Well, it's more than just risks, it's also typologies. Do you see that?
I do.
It's both typologies and risks. So that really records your view that the relevant risks and typologies are properly analysed and dealt with in those reports.
That's correct. I agree with that.
And you would agree that one way to conduct a risk assessment is to engage external experts like Promontory or Deloitte or Initialism or Murray Waldron.
I agree with that.
And you
But I would also,
you offer this service to your clients.
Yes, I do. If I could just qualify that answer, that it is absolutely correct that external consultants are engaged to consider typologies and risks, but the crucial part of that is they have to then apply it to the reporting entity to which they are providing that service. So in this particular case, Crown. And so by that I mean that they then apply those typologies and risks to the nature, size and complexity of the entity that's undertaking the risk assessment. And that's where I perhaps differ in that I cannot see that they've done that in the context that I would expect, in my experience, from the purposes of the MLTF risk assessment.
So what you've just said, Ms. Waldron, where do I find that in your report?
I would just say in the paragraph that you have referred me to there, 5.1.
5.1 doesn't say anything like what you just said.
Well, I'm sorry. It does say that I rely on the reports provided and the risks and typologies identified by others, and I have referenced the need to apply that to the nature, size and complexity of entities specifically at other parts of my report and indeed in the responsive paper to Crown's.
Well, just sticking with the report itself, not the responsive report, where do I find what you just said in your report itself?
Well, it is a requirement of the rules to apply those considerations to the reporting entity's nature, size and complexity.
Where do I find it in your original report?
If you'll just give me a moment, I'll see if it's set out in that way. Yes, if you refer, if I could refer to paragraph 3.3.1, which is at 0183.
Where is the reference to experts in that, Ms. Waldron?
No, I didn't say it was a reference to experts. I was saying that that the risk assessment that you need to conduct to assess your MLTF risks must have regard to the nature, size and complexity of the business, together with those other factors that I spoke of earlier, being customers, designated services, products and channels. Now, what I'm saying is that I rely on the experts in paragraph 5.1, I think we were just discussing, and the typologies and risks that they identify as being relevant to casinos. What I don't see is that it's been applied in the Crown context.
That's the part that I'm looking for. Where do you say that the experts haven't done that in the Crown context? Where is that contained in the body of your original report?
Well, it may not be set out in those specific terms, but it is based on the requirements of a risk assessment and the opinion that I have formed that it does not meet those requirements.
So that's really reading between the lines of your report, Ms. Waldron.
I could have set out in detail the sections of part 9.1, but I have not.
What I'm directing your attention to is not the rules themselves, because the rules themselves are able to be obtained from the Act. I'm directing your attention to that your analysis that you've just explained about what the experts did or did not do is not contained in your original report. Do you agree with me?
I agree that it's not set out in those terms, yes.
Now, Ms. Waldron, did you, in the course of setting out to determine who you would interview, seek to meet with any representatives from Deloitte?
No, I didn't.
Initialism?
No.
Promontory?
No, I didn't.
PwC?
No.
Now, you say in your responsive report sent last night that you have not conducted an independent review.
That's correct.
That's at paragraph 10 of your responsive report. How long would you expect an independent review of an organisation as complex as Crown typically to take?
It's hard to say because sometimes it depends on the number of documents and the program itself. So it's very hard to put a specific time frame on it. But for a complex entity, it would certainly be quite a length of time. I'd suggest several months.
You're aware from the position paper from Crown at paragraph 42 that Crown has engaged Exeger to conduct an independent review of the program. You're
Yes, I'm
aware
aware of that. Yes.
And that is to commence at the end of 2021.
I believe that's the case, yes.
If you take it from me that Exeger thinks it'll take about 3 months with a team of about 6 people, does that sound about right from your experience?
That's obviously Exeger's approach, and I wouldn't disagree with that.
And Exeger are starting in December 2021 so that they have a sufficient pool of data to examine the effectiveness of the program. Do you consider that to be appropriate?
I'm sorry, if you could just repeat the question.
So Exeger is starting in December 2021 so that they will have a relevant pool of data to examine, and I'm asking you whether you consider that to be appropriate.
Yes, for the purpose of conducting an independent review, which I have not done.
But you would agree with me that an independent review is the way properly to assess whether there is compliance with the AML CTF legislation?
No, it could be done in various different ways. And an independent review takes into consideration 2 things, and I'm summarising this. it takes into consideration the design effectiveness of the program, so the technical assessment of the program based on the risks that the organisation faces, and the operating effectiveness of the program. That is, whether it's being implemented and it is complied with. That is not the scope of the work that we've been asked to do, nor is it an opinion I've given.
I could turn now to the issue of implementation. You address that in your report beginning at page 191 in section B6 of your report. And one of the questions is directed to whether the program, if implemented, would allow Crown to satisfy its obligations. And you answer that negatively at page 192 at paragraph 6.2.1. Do you see that? I'll ask you to read that to yourself. But you acknowledge that Crown has systems and controls in place to meet the obligations set out in the Act and the rules.
I do acknowledge that.
And some of these you set out at paragraph 6.2.2.
Yes.
Just so I can understand what you are saying here, your conclusion about implementation follows from your earlier conclusion about the program not being sufficiently risk-based.
That's correct.
But you aren't saying that there's a deficiency in the underlying systems and controls as identified in 6.2.2.
The systems and controls in 6.6.2 are not all of the systems and controls that Crown has in place. And I'm not saying that they're deficient. I'm saying they're not appropriately risk-based.
In fact, you say that an assessment of the underlying systems and controls is not within your scope.
That's correct.
You aren't saying that those systems and controls are not reflected in an update to the Part A program.
I'm saying that they are not updated in the Part A program. So the Part A program does not reflect the systems and controls in 6.6.2.
So that's a point about form, is it not, Ms. Waldron?
No, I don't necessarily agree with that. I think that a program needs to be updated to reflect the systems and controls that a reporting entity has in place based on the risks that it's exposed to. It may sound like a technical argument, but in my experience, without an updated program you can evidence is how you manage your risk, there is a potential compliance issue.
You're aware that Crown is in the process of revising its Part A to be tabled next month.
I am.
At paragraph 18 of your report sent last night, you dispute the claim that transaction monitoring is one of the most important components of the AML CTF program.
For casinos. I do hope I said that.
Let's go to paragraph 18 of your
Yes.
report.
Yes. I say, in light of the exemptions afforded to casino under the Act and the rules, we would dispute the claim that the transaction monitoring program is one of the most important components.
So what is the basis for that view, Ms. Waldron?
The basis is that not all transactions are monitored because the Act provides an exemption in relation to the KYC and identification of some customers. So to put it simply, not all transactions are going through the Crown systems and capable of being monitored because they are non-carded transactions.
So if transaction monitoring is not one of the most important, what are the most important in your view?
Well, there's a range of things. I think, obviously, the identification of customers, knowing what risks that they pose, knowing the products and channels that and the risks that they pose. I think training is a key component and a key control in the casino context. because there's a large reliance because of the very nature of the business on manual monitoring. So awareness of what particular risks and scenarios or typologies of a money launderer in a casino context is very important.
And in your mind, that's more important than transaction monitoring?
No, I didn't say that. I just said that it is one of the key components and one of the controls. I'm not suggesting that one is more important than the other, and I think that is the point of disagreement with the Crown position paper.
So you accept that transaction monitoring is important?
I do, yes.
Your quibble is whether it could be described as the most important.
Yes, that's correct.
Or even one of the most important.
I think it's a very important control. I think in the context of a casino, given the exemptions afforded to it under the Act, it is not the most important control.
At paragraph 22 of your further report, you say that Murray Waldron notes this document has not been reviewed previously. Do you see that?
I do.
You do not go on further to say that it was available to you.
That's correct. My apologies if that is an oversight.
It was available to you, wasn't it?
Yes, I believe it was.
So
I was relying on an earlier, apologies, I was relying on an earlier version.
Earlier version of what?
Of the document, I think, that was referred to.
Is this a reflection of the lack of time, Ms. Waldron, that you are unable to look at this document which was available to you?
No.
Now, you see in the position paper at paragraphs 15 to 18, this is the Crown position paper, that Crown says it had previously undertaken the documentation of MLTF risk assessments. Do you see that?
I do.
And in your responsive report at paragraph 12, you say that you were aware of some of these documents from your interviews with Mr. Blackburn and Mr. Sutherland. That's in the first paragraph of paragraph 12.
Yes.
You didn't ask for those documents, did you?
Yes, indeed we did. I asked for them from Ms. Seegers, the Chief Risk Officer, and I asked for any risk assessments that Mr. Blackburn and or Mr. Sutherland or others relied on in relation to the 2020 program.
Ms. Waldron, what I'm trying to understand is that you say that in your interviews with Mr. Blackburn and Mr. Sutherland, the documents referred to in the paragraph were referred to. And I'm asking you whether, even though they were referred to, you asked for them.
I did ask for them.
You did, or you did not?
I asked for the documents that related to previous risk assessments or risk registers, yes.
You say further down the page that both these documents have been made available to us on the 11th of November.
In fact, it should have been the 10th. It should have been the 10th. I apologise.
It should have been the 10th.
Yes.
So you haven't had an opportunity to interrogate those documents which are referred to in the position paper?
Yes, I have. I was provided with those yesterday. It's a typographical error of the date.
Right. You've fully undertaken a review of the documents provided to you recently?
I received them yesterday, yes.
I'm asking you whether you've had the opportunity fully to review them.
Yes, I believe I've reviewed them fully.
we go, please, to the penultimate bullet point in paragraph 12, where you're referring to a document that was prepared by Miss Louise Lane in June 2019,
Yes,
and you say that the assessment is useful in part, but has limited applicability as it relates to the designated services offered, Kijibat. That should be but.
yes,
Does not assess MLTF risk in the context of the customers, channels or jurisdictions Crown Perth might be exposed to. You see that?
I do.
Are you sure about that, Ms. Waldron?
Yes, I am.
All right. If we go please to CRL.614.001.0670. And so this is a memorandum sent to Mr. Felsted, and it's a draft version of a risk register. With the actual body of the document following the covering email commences at 673. And have you seen this document before, Ms. Waldron?
Yes, I have, yes.
So if we look please at 675, there is a reference to customer type risk. You see that?
I do, yes.
So your conclusion with respect to customer type risk is erroneous.
No, actually, what I am saying here is it's unclear how they have assessed the risk based on the attachment to this memorandum. So they talk about the type of customer. They say that I won't jump ahead, but they have looked at the types of customers that Crown has, and they arrive at the conclusion, or Miss Lane's arrived at the conclusion here, that the risk posed is low. What I'm saying is there's no, I have no way of knowing how that conclusion was arrived at in relation to customers, and so its applicability is somewhat limited.
Ms. Waldron, the text of your responsive report says that the assessment does not assess MLTF risk in the context of certain things. That's all it says.
Yes,
This report does assess that type of risk. It mentions it at page 675 insofar as customers are concerned. With respect to jurisdiction, that appears at page 676. Operator, please bring that up.
yes,
And when we get to page 677, it addresses products, service risk and delivery method risk. And as I understood your evidence this morning in an answer to a question from Mr. Futrell, that's channels, isn't it?
yes,
So it addresses channels, it addresses jurisdictions. There is a business risk register at page 696, 683 to 696. Did you give that any attention, Ms. Waldron?
yes, I did.
So there's a rating system involved there, and
That's right, likelihood and consequence.
and there's specific money MLTF risks associated with those services that are casino specific. You'd agree with me?
I would.
And then at 697, there's a Crown Entities Risk Register. Did you give that any attention, Miss Waldron?
I'll just wait till that. Yes, I did. Yes.
And you will see that at page 712, for example, there is reference to changes to the external environment this is item 40 and 41 on page 712. Do you see that?
Yes.
And that is a matter that you criticise Crown for as not giving any attention to. That's correct, is it?
I'm sorry.
You go ahead.
Oh, sorry.
Yes.
I said in relation to the November 2020 program, which is approved by the board, version 2, that there had been no enterprise-wide risk assessment in the manner that an Annexure B requires it to be done. My understanding of this document is that it was created in 2019 and associated with the 2019 program, which I believe the cover memo sets out that had not been implemented in light of Mr. Stokes recently joining Crown. So I cannot consider this document as being part of the version 2 program because one was not incorporated into or referred to in the 2020 program, and it doesn't comply with the methodology set out in Annexure B, which forms part of the program. So I am aware of this document, but Mr. Blackburn himself does not rely on this document to say that it applies to the version 2 program that is currently the board-approved program for Crown entities.
Do you see in the position paper at paragraph 15 and following, Crown position paper, Crown asserts that it undertook prior documented MLTF risk assessments. Do you see that?
On paragraph 15, sorry?
Yes, 15 and following.
Yes, I do.
So that is Crown's assertion, but are you considering Crown's assertion or not?
In fact, I had seen those documents and referred to them in my original report as being provided by Ms. Seegers, and they were referenced in part at 3.3.4 on 0184.
You're aware that Mr. Neil Jeans of Initialism did conduct a review.
Multiple reviews, I believe.
And you have no reason to doubt the competency of Mr. Jeans.
Not at all.
And you address at paragraph 14 of your reply report a conclusion Mr. Jeans arrives at, where you say that on your reading, the Initialism report does not reference an MLTF risk assessment. Do you see that?
I do.
You would accept that Mr. Jeans understands that the AML-CTF Act and Rules requires a risk assessment to be undertaken?
I do.
So can we go then to the Initialism report, which is at CRL.728.001.0192.
Yes, I have that.
So you would see that Mr. Jeans expresses the view at the second last paragraph of the letter. We have worked with Crown and its legal representatives to develop a Part A AML-CTF program and the supporting policy and procedures. Based on our work, we are of the opinion that the revised documented Part A, as drafted, complies with relevant AML-CTF rules and is appropriately designed to identify, manage, and mitigate the money laundering and terrorist financing risks faced by the reporting entities that are part of the Crown Group. Do you see that?
I do.
So, accepting, as you do, that Mr. Jeans understands the AML-CTF Act and rules, he is there saying that relevantly, the steps required to be undertaken have been undertaken.
I see that.
Thank you. Is that a convenient time, Commissioners?
It is. Now, what do you wish to do about the documents?
Well, we would like to examine them over the luncheon break, Commissioner, both the the note as well as the other material that I called for. I think Mr. Futrell is going to answer the call.
I think there were 2 calls I can recall, without wishing to be. The one dealt with the email, it's an email that we can answer, but in order to answer the second call, which I think relates to the scope document, someone's going to need to speak to Ms. Waldron.
I think there's 2 questions. There's the question of whether or not the report that's been tendered is the final report.
Yes.
There was a second question I thought about the documents that Ms. Waldron had sought from Crown through this mechanism of notices to produce.
Yes, I didn't think there was a call in relation to that.
No,
one.
there wasn't. I think there wasn't a call, but what Mr. Dharmananda said to the witness was, in the break, can you find them? And I think the witness said, well, I'd need to speak to the solicitors to do that.
That's right. So that was the other aspect. I think we would, if we may be able to identify the NTPs ourselves, I need to speak with my instructors about that. But if not, we may need to speak to Ms. Waldron about that over the break as well. So I don't know if friends prepared to allow us to do that in order to sort that issue out. Because obviously we should otherwise not speak to
Mr. Dharmananda?
No, on the basis that it's confined to those topics, then that seems appropriate with respect, Commissioners.
All right, thank you. We'll see how we go. And Ms. Waldron, we break for lunch now, and we'll come back at 2 p.m. our time, which is 5 p.m. your time.
Thank you.
All rise.